All right, why don't we get started? People are still coming into the meeting, but we'll begin. My name is Erik Daly. I am a partner in the corporate and business section at Miller Johnson. This is the second in our series of Monday morning COVID roundups. This is something we started last week to provide a regular webinar first thing to start the week for people to know what's changed, what's likely to be relevant, and to start their week off sort of in the know with a list of recent developments. And we thank you for joining us. We hope you'll continue to do so. This morning we have a lot to get to, so I won't talk very much. Mainly I will be moderating and moving things along and watching the Q&A. Briefly, though, I did want to provide a high-level overview of the status of the American Rescue Plan, which is the legislation or the proposed legislation that is working its way through Congress. You may have seen over the weekend that the Senate approved a version of the bill that's very similar but different in some important ways from the version of the American Rescue Plan that was approved by the House about a week ago. So that bill looks like it's headed back to the House right now for a vote on Tuesday in all likelihood. And so may, assuming it passes again, more or less along party lines on Tuesday, may well become law either that day or shortly thereafter, midweek. So we'll be presenting webinars that are more subject matter specific, more program specific on elements of the American Rescue Plan, and not focusing on that as much this morning as it's still working its way toward actually being signed into law. But I'm sure we'll have much more to say and present on that topic, obviously, in the coming weeks. So with that said, I'm going to turn to the rest of today's agenda. And you can see here that we plan to cover the current state of Michigan's health and safety orders and vaccination prioritization. We'll have an update on COVID-19 and immigration-related topics, plus some that may or may not be so directly related to COVID-19, but are relevant in the current environment. Then we'll get an update on some information about the Jinns Act, which is a proposed government grant program along the lines of the Shuttered Venue Operator Grant Program that the SBA, the Small Business Administration, is administering. This is separate from the American Rescue Plan. I believe CJ and Elise will provide some more information on that. And then lastly, we'll have an update from Tripp VanderWal on the recent Department of Labor and IRS guidance related to some employee benefit plans issues. So that's what we're going to try to get through in an hour. Please, thank you again for joining us, and please welcome Sandy Andre to the webinar. He's going to kick things off for us on the health and safety orders and vaccination prioritization topic. Sandy, I'll turn it over to you now.
Thanks, Erik. Good morning, everybody. As the slide shows there, we're going to cover a couple of different things today. One, we're going to talk about some of the recent MDHHS orders, but we're also going to review so the COVID-19 emergency rules. There has been an update, not on the Miosha front, but through a different agency. And so we'll go through each of those this morning. Next slide, please. Let's start with the first one, which kind of feels like old news, even though it just went into effect on Friday. It was an updated MDHHS gatherings and face mask order. Middle of last week, Governor Whitmer and Director Hertel held a press conference and announced an updated gathering and face mask order, which generally increases capacity limits and extends curfews for some commercial venues such as restaurants and bars related to the decrease in positivity rates, increase in vaccine availability, all of those pieces together. What's important to remember about this particular order became effective last Friday, and right now it is effective through April 19th. Now, that date is important to keep your eyes on because if you remember, the previous order wasn't set to expire until the end of March. So this is a good inkling to us that the folks at the state government are watching that scientific data and are willing to make changes to the existing orders based on what they are learning, rather than some of these expiration deadlines that actually live in the order. So as I mentioned, generally the updated order contains capacity limit increases for commercial venues from generally from 30% now to 50% for restaurants, bars, museums, and various entertainment venues. Non-tribal casinos are limited to 30% capacity. Outdoor gatherings, of course, for residential went from 25 to 50, and in non-residential are now up to 300. Indoor gatherings also increased for residential type of settings. They're now at 15, and for non-residential settings for indoor gatherings, those are limited to 25, with, of course, face mask requirements and social distancing requirements for those as well. So a brief update on the gathering order. Next slide, please. Where we saw a lot of movement last week is related to vaccine prioritization guidance. And I've included the link here to the state's COVID vaccine website. And there you'll find the prioritization plan and phases and various pieces of very helpful guidance documents that talk about how to communicate information about the vaccine, maybe to your employee group, or just various community resources for vaccine availability. But we saw a lot of movement here last week. So you may remember late the previous week, that vaccine prioritization, or excuse me, in mid-February rather, that vaccine prioritization guidance indicated that starting on March 1st, food processing and agricultural workers would become eligible for the vaccine. And so last week, we saw a guidance document posted on that website that told us what MDHHS's definition of food processing and agricultural workers were, to help us drill down on that a little bit more. And then we saw two additional updates last week as well, one on the 2nd, which quickly became replaced by the vaccine prioritization guidance that was updated on the 3rd. And the really exciting information about the information contained on the March 3rd guidance document indicated that by March 8th, so today, individuals in Michigan over age 50 with certain medical conditions and disabilities, and caregiver family members and guardians who are 16 and over, who are caring for children with special health care needs, have access to the vaccine effective today. Obviously, that is still dependent on availability in your area, but in terms of being an individual who is eligible to receive the vaccine, if you are someone or you have employees who fall into one of those two groups, they become eligible to receive that today, irrespective of their employment relationship with you, right? If you've kind of been waiting for your employees to have access to the vaccine based on the type of employee they are, as an example, these two pieces of criteria are completely separate from anybody's employment relationship, so that's good news. The other piece in that March 3rd updated prioritization guidance indicated that individuals age 50, regardless of their health status, would become vaccine eligible by March 22nd. So just a couple of weeks out for those two groups. In terms of those who have access to the vaccine today in that caregiver category, MDHHS tells us that the caregiver family members include folks who are caring for individuals with physical, developmental, mental, sensory, behavioral, cognitive, or emotional impairment, or any limiting condition that requires medical management, healthcare intervention, and or use of specialized services or programs. So from MDHHS's standpoint, that's the group of people that they're considering eligible into that caregiving category. So good news, and certainly definitely steps forward there that are important. Next slide, please. Turning to the Department of Agriculture and Rural Development, they issued an emergency rule on March 1st that generally, if you're not working in this area, this may have slipped under the radar, but it was an important development. So last week, effective March 1st, Department of Agriculture issued an emergency rule that is going to remain in effect for 6 months unless it's rescinded sooner, that generally requires owners and operators of agricultural labor housing camps to do certain things. Now, generally, the requirements in this order mirror what the Miosha emergency rule would require of these types of employers, but contains a little bit more detail in a few more requirements for this group. So here, the first bullet point you see, the first requirement is to develop and implement a COVID-19 preparedness and response plan. And if you are an employer who is covered by the Miosha rule, hopefully that is old news to you, and you've got your plan and you've been updating it all along. This order requires specific items to be in the response plan, including identifying a camp supervisor, which is, again, if you've been compliant with the Miosha rule, you already have a worksite safety supervisor, so that could certainly be the same person. It includes a requirement for a training component, which the Miosha rule also does, that you're required to train individuals living on the property related to social distancing, proper PPE, and the enhanced sanitization measures that you have implemented. You are required to develop and maintain a listing of names and emergency contact information for each camp resident, something you may already have. And then certainly you're required to establish a specific COVID-19 information posting location so that the individuals residing on your property know where a physical location or an electronic location, where to go if there are any developments that you are needing to share with them relatively quickly related to COVID, they would know where to look at those pieces. There's also a posting requirement. The order requires that owners and operators post certain pieces of information in English, Spanish, and other language if more than 5% of camp residents speak that language. And those postings include the camp name and address for 911 and emergency services purposes, the name and phone number of the current camp supervisor, the phone number for the local health department, phone number for the Michigan COVID-19 hotline, information on health clinics that are within 10 miles of the camp, information and location of PPE and various COVID-19 mitigation supplies, and a copy of the camp's current licensure. And then the last bullet point here, that owners and operators are required to implement what I'm calling a confirmed or suspected case protocol. So for those listening, you're probably generally familiar with the Miosha requirement that we kind of call a positive case protocol. When you become aware of one of your employees experiencing a positive case of COVID-19, there's various steps that you need to do, notification requirements, and so on and so forth. Same goes here with owners and operators of these specific migrant and agricultural working housing facilities, right? So you do need to report the name, address, living information immediately to the local health department, and that's immediately, but not later than 24 hours. Arrange for that resident to be evaluated by a healthcare provider through the local health department or the local FQHC. So that's a new requirement that doesn't exist in the Miosha rule. You're required to provide isolation or quarantine housing for that individual depending on the circumstances, and then posting notices at entrances of those isolation and quarantine facilities so that anyone entering knows that they need to wear proper PPE, including face masks and gloves, and wash their hands thoroughly when they leave. Okay, so that order may have flown a little bit under the radar, but wanted to make sure to bring that to your attention today. Next slide, please. But speaking of Miosha orders, as we were all getting ready for this webinar, the number one question that kind of fell into the employment area was related to the Miosha emergency rule. So just wanted to quickly revisit that. Remember that this Miosha rule became effective back in October. And at the time that it was released, we knew that it would remain in place for at least 6 months unless it was rescinded sooner, but could be extended for an additional 6 months. So 6 months takes us to April 14th, right? So we're within a few weeks, we're within can see it. And so the question we've been getting is, what do you guys know about, is it going to be extended? Is it going to be modified? What do we know about it? And so without a doubt, the biggest question comes down to people asking us about Rule 5 sub 8, which is the remote work requirement. And so the point here is to remember that the remote work requirement is tied to the Miosha emergency rule, and it is not tied to any updated MDHHS epidemic order. If you remember back in the fall, Miosha started a state emphasis program on office environments right around the same time that the MDHHS announced that 3-week pause right before the holidays. And so I think there was some confusion that the remote work requirement was something that was determined by MDHHS. And so we needed to be really watching those orders to see when folks could return to the office work environment. And that's not the case, at least as it exists right now. So the entity that is spoken on that requirement is Miosha, and it lives in the Miosha rule. And so we will be watching that very closely, and it appears that Governor Whitmer is assembling a work group of various business leaders across the state to discuss this very issue. So we saw a lot of movement, obviously, on capacity restrictions and dine-in restrictions and things like that. Now that MDHHS has expanded capacity limits in that area, it does seem that there is now some attention from the business community related to the remote work requirement. And so we will watch that, and you will certainly hear from us if anything changes on that front. But as of today, still the rule, right? That the starting place needs to be a prohibition on in-person work to the extent that an individual's work can be performed remotely in a feasible manner. And the last piece I will briefly touch on this morning, next slide, please. Also last week at the same time, the MDHHS epidemic order was updated. MDHHS also issued a new residential care facility order. It rescinds and replaces a previous order from December 2020, and it became effective immediately on March 2nd with no expiration date at this time. Generally, it permits facilities to resume communal dining and group activities. It continues many of the resident and employee protections that previously existed related to testing, and now has a requirement really that facilities must support and accommodate residents receiving visitors under certain circumstances when there are certain restrictions in place and certain measures in place at those facilities. And I'll just have go through the next 2 slides here. There's some very helpful information on the MDHHS website, FAQ type of information, infograph type of information. Next slide, please. Interpreting the residential care order that is particularly helpful. And the next one. And one more. But I'm not going to get into that order too much. I'm actually going to solicit you to attend our webinar tomorrow, where 2 of our colleagues, Hillary Scholten and Tim Gottwald, are going to dive headfirst into this order and tell you everything you need to know. So with that, I will turn it back over to Erik. Everybody have a great day.
Thank you so much, Sandy. That was very helpful. I appreciate the overview. And while we're transitioning, it looks like there may be 1 or 2 questions. If you have time in the chat box, we can circle back up later to any that we want to address live with the group. But thank you so much, Sandy. As always, you're a hugely helpful resource in tracking all of the orders that we and our clients need to be aware of. So with that, I'm excited to publicly welcome and introduce Hillary Scholten, who is a new member of the Miller-Johnson team, has a background in the immigration area, in addition to public service and government affairs, where she'll be contributing to some new efforts at Miller-Johnson. But today, Hillary, I'd like to welcome you to talk about some of the topics related to immigration and COVID and the first 50 days of the Biden administration.
Thanks so much, Erik. Thanks everyone for attending. It's great to be here with you today and to join you tomorrow. As Sandy mentioned, we're going to be giving a little bit more in-depth analysis on the residential care facilities update. It was pretty involved, so if that impacts your work at all, do tune in tomorrow. But today we have a great update on COVID and immigration. Immigration impacts some of our work in big ways, essential ways, and in others only in tangential ways, right? We are all subject to I-9 verification requirements, which we'll get to at the end of this slide. I just have a brief update today, but do stay tuned. We're going to be issuing a really comprehensive client alert later today, covering all issues immigration related in the first 50 days of the Biden administration. Today's just sort of a high level, what you need to know to get started on your Monday. So first, immediately when the pandemic began, the United States began limiting individuals who could come into the United States to protect and prevent the spread of the coronavirus itself. Some of those have remained in place and others have been stopped and normal processing has resumed. One that we all watch very closely is our relationship with our neighbors to the north and the south. And just at the end of last month, the Biden administration did decide to extend normal visa processing, normal travel between the United States and Canada and the United States and Mexico. So that is still on pause for now through the end of this month. There are exceptions for emergency travel. We have a full definition of emergency travel, and that does include certain exceptions for work and lawful cross-border trade. So truck drivers are getting across, goods are getting across. And so that is important to keep in mind, however. And there are limited services at these consulates, at the embassies, at the US processing centers, which are causing additional backlogs. Now, we also have geographic restrictions from certain areas that have had high instances of the coronavirus. The full list is right there. That has no effective end date at this point and is in effect until terminated by the president. And we're watching that very closely. We do see a good number of individuals coming to the United States for work, particularly from the People's Republic of China and the United Kingdom. Next slide, please. We have additional entry and admission issues related to not only protection of the coronavirus, but the United States has also started restricting entry in order to address the other critical issue, which is economic recovery. At the end of 2020, the outgoing Trump administration issued a proclamation called the Suspension of Entry of Immigrants and Non-Immigrants Who Pose a Risk to the US labor market. So essentially they stopped issuing all routine visas in, around the idea of, we want to help stimulate the US economy. We don't want to take these jobs away from US workers. Of course, those of you who rely on essential workers, engineers, service technicians to keep the place running know how frustrating and difficult this has been, because in so many instances that key engineer or plant supervisor is the link to productivity and creating so many other jobs. And we've been working on a number of emergency cases involving those particular types of issues. So the Biden administration has had a few changes around those issues. Essentially, the suspension and entry of immigrants and non-immigrants involved two key presidential proclamations, Proclamation 10014 and 10052. 10014 involved the entry of immigrants, people who want to stay here long-term, permanently. Now, President Biden rescinded that order effective immediately February 24th. So those types of entries may resume at this point. However, he did not rescind Order 11052, which relates to non-immigrants. So your temporary workers coming in, your H's, L's, and J's specifically, and their dependents. If someone already had that visa and was present in the United States, they may remain and renew that visa, but they're not allowing any new entries on those categories right now. Now, it's important to note that there is a national interest exception where you can make an argument, hey, we need this person here. It's in the national interest that they come here, that they be provided an exception. It's our understanding that there are, as I mentioned, these key technicians, software engineers, a doctor, a highly skilled automotive technician who we need to get here for a certain key function, and that would constitute a national interest exception. We're willing to make those, those arguments and push for those exceptions, but it is important to note that it is not business as usual when it comes to these categories. We've also seen major changes with diversity visa applicants. A lot of people rely on this catch-all category to, to bring these individuals here. For 2020 approved applicants, initially that processing was rescinded. Those visas were revoked, subject to Presidential Proclamation 10014, and that has been reinstated. We are now seeing that these individuals are approved. I know we've seen a number of clients, who have had these visa categories approved for some of their key workers. Those approved visas do contain an annotation that says, this person may not travel because of Presidential Proclamation 10014. However, they still may travel. It's a wonky situation, but we have an order from the Department of State allowing and authorizing travel despite that annotation. For the 2021 diversity visa applicants, right now we're in a wait and see approach, and we're just waiting for embassy notification on processing on those visas. Let's move on to the next slide. So consular and agency processing, we have seen, just as other workplaces around the United States have ground to a halt, the agencies who process these visas are in no different situation. Consulates are shutting down to prevent the spread of COVID-19. That creates significant backlog. A lot of these places haven't had systems in place for remote work. So, there are just months and months long backlogs around the country with these visa processing. Again, I want to stress to you that there are exceptions for emergency situations. If you find yourself in a situation where you are relying on, that key worker to come in and get your systems in place, run your equipment, the only person who can do it, that constitutes an emergency situation. We're making those arguments, getting help from our delegates in Congress to get emergency processing going for these individuals. So if you find yourself in that situation, we're happy to help with something like that. So next slide, we do have one more. Yeah, employment verification. This is one that has a much broader implication for everyone. So it's important to note that even though normal employment verification processes were given a little temporary reprieve because of COVID-19, the verification is still required. Remote verification was approved during COVID-19. All you employers out there know, it is an in-person process that has to happen within 3 days of a new hire. There has been a suspension of that, and remote verification was allowed for the first time, really ever. However, some employers have been confused and thought that meant a suspension on employment verification altogether. That's certainly not the case. You're still required to verify, but you may do it remotely via Zoom, holding up the documents, getting an email with the documents scanned in there. It's important to note that this was all happening, these loosening of the rules of in-person verification was suspended only for workplaces that are considered 100% remote. So, if you've got some people still coming in, the expectation was you could still require people to come in and verify those documents in person. Now, again, there is a little bit of a leeway given there, but that was the operating expectation. Once operations return to normal, employers are expected to verify employment documents within 3 days of that return. Now, there's no definition of normal. I don't know that there will be for a long time. What is normal now? No one knows. But the assumption is once things start getting back online, you will be required to verify those documents in person in the workplace. Now, it's important. We have, some employers who have made massive amounts of hiring over the last 12 months. And, if your business comes online, in the next month or two, that's going to be a really heavy lift. So start being proactive, start thinking about, what it's going to look like to get your employment documents verified once your business starts returning to normal. Oh yeah, but wait, there's more. Stay tuned. I'm glad I put this slide in because we have a great client alert coming out that assesses the full panoply of actions under the first 50 days of the Biden administration, including what many of you know is a massive comprehensive immigration reform bill. A lot of attention has been paid to the humanitarian aspects of the Biden administration these first 50 days. Regarding family separation and asylum processing, but there's a lot that impacts businesses and our clients in there as well. And we'll be covering all of that. So stay tuned for that client alert later today. Thanks so much. I'm happy to answer any questions that you all might have.
Thank you, Hillary. That's extremely helpful, and certainly will look forward to the client alert and the webinar tomorrow morning to get into even more specifics on that front. And yeah, if you do see any definition of normal published, I would love to be on that list of people who get the definition of what's normal, because I don't know anymore after the last year. So I'm sure we'll have a lot to digest in the immigration area, all joking aside. So there may be some questions in the Q&A box, but we can circle back up for any live questions at the end. I do want to keep things moving on to our next topic with CJ Schneider and Elise Hildreth, who will talk a bit about the Jinns Act. And I'll turn it over to CJ to kick things off. And Elise, thank you.
Sounds good. Thanks, Erik. Good morning, everybody. My name is CJ Schneider. I'm a partner in our litigation section here. And with my colleague, Elise Hildreth, we wanted to give you a quick update on a new separate potential stimulus act that's making its way through Congress. So this is different from the American Rescue Plan. This is called the Gym Mitigation and Survival Act of 2021, or the Jinns Act for short, pretty good acronym. This was introduced in the House on February 5th, 2021, which means it's still very much in its infancy stages. It's not yet the law. It's still a proposed bill. The reason we wanted to make sure everybody was aware of it is this provides a very significant amount of direct funding to an industry that has been one of the hardest hit by the pandemic. So when you think about gyms and fitness centers, these are the types of businesses, usually small businesses, that were required to close for a protracted period of time. That suffer the most from social distancing requirements. I mean, this is an industry that's been hit pretty hard. And this bill, if it becomes law, has the potential to provide quite a bit of financial relief to that industry. So as you can see on the slide, the Jinns Act would provide up to $30 billion in financial relief to gyms and fitness centers. Those funds would be distributed through a grant program that would be administered by the SBA. And as Erik mentioned at the outset, it's pretty similar to the SVO, or the Shuttered Venue Operators program, although I would say that this one, if it goes through in its current form, is much less restrictive than the SVO program is. There's a lot less hurdles you have to jump through in order to get this money. So let's go to the next slide and we can talk a little bit more about it. So who's this act for? Who's the grant program for? This would apply to what are called fitness facilities under the proposed bill. Those are businesses or organizations that provide instruction in or offer space for physical fitness. So that can be, your gym down the street where you go to do workouts. It could be the gymnastics facility where your kids go after school. I mean, any type of place that offers sports, physical fitness, those kind of things. There are two major exceptions though. Facilities that offer golf, hunting, sailing, or riding who are not covered by this, and state-owned facilities are not covered by this. So this is really meant to target much more of the like physical fitness side of the industry than perhaps some more of the sporting side of the industry. And the certification that's required for businesses who would apply for this grant is pretty broad. I mean, it doesn't require all that much. You'll see down at the bottom, you have to certify that the uncertainty of the current economic conditions make the grant necessary to support ongoing operations and that the funds will be used to retain workers or for other allowable expenses. What I think is significant about that is that it's not expressly tied to COVID, or at least the initial certification isn't, right? I mean, it's much broader. It deals with the entirety of the current economic situation. And so at least, and you'll see here in a little bit, it's not tied specifically to COVID in the first instance. There is a portion of it that is, but at least in the first instance, it's not. So let's go to the next slide here. So how much are the grants? There's two categories of grants, and this is where you start to see the distinction between COVID and not COVID related grants. The initial grant would equal the lesser of 45% of an applicant's gross revenue from 2019 or 25 million. So it's a $25 million cap, which I don't think is going to apply to most applicants here. This one is not related to COVID, right? This is the initial grant is pretty much open to any fitness facility that can make those initial certifications. So you get 45% of your gross revenue from 2019, or if you opened after January 1 of 2019, you get up to 6 times your average monthly gross revenue. So that's the initial grant. The supplemental grants piece, this is kind of round 2, is tied to COVID, and that becomes available if the applicant's revenues from quarter 4 of 2020 are 1/3 or less of its revenues from the same quarter in 2019. So you compare fourth quarter of 2020 to fourth quarter of 2019. If your Q4 2020 revenues are 1/3 or less of 2019 due to the COVID-19 pandemic, that's where this comes in, you can get up to 25% of the initial grant amount. And there's a combined cap on both of them of $25 million per applicant. So as you can see from the numbers, there's a significant amount of money that would be available to help the small businesses that have suffered in this space for quite some time. And, you know, this is something that's gaining some traction in Congress. I think that I saw there were more than 50 co-sponsors in the House as of this morning. So it's making its way through. And I'll turn it over to Elise to walk us through the rest of it.
All right, thank you, CJ. Next slide, please. So getting to the part where most people be hyped about, what can we use the grant money for? And that can be generally characterized as ordinary and business expenses, such as payroll costs, payments to independent contractors, rent, maintenance costs, utilities. So it's pretty broad what you can spend it on. What you can't spend the grant money on is buying real estate, payments on loans that originated after February 15th, 2020. You can't invest or lend those funds or use it for political campaigns. Next slide, please. Now, when can you use it? So going back to those initial grants, you can use it for expenses that were incurred between March 1st, 2020 and December 31st, 2021. If an entity receives a supplemental grant, you can use that for expenses between March 1st, 2020 and June 30th, 2022. If you also receive a supplemental grant, you can use it for the original time period as well. Now, what's important part of this bill is that if you don't use it, you lose it. If you get an initial grant, you have to use that money within the first year. After that, you have to give it back to the SBA. If you receive a supplemental grant, you have 18 months to spend whatever grant money that you do get. Next slide, please. Now, this is an important part and why we're kind of bringing it up this early. There is a priority within the bill as it stands today. So during the first 14 days, the grants may be awarded. Priority will be given to fitness facilities that are serving marginalized and underrepresented communities, especially if that specific fitness facility is owned by a woman, veteran, or it is minority owned. Special priority will be given there too. So it's important to know this priority so that you can get your applications together in the event that this bill actually passes. So next slide, please. If you have any questions, you can contact CJI about this. All right.
Thank you very much, Elise and CJ. I'm sure if the bill does continue to progress and become law, there will be questions as we've found in the other contexts with SBA administered programs, which, as you alluded to, CJ, it's interesting to see how SBA has been deployed over the last year, since it doesn't necessarily just focus on small businesses for some of these programs, at least as you would maybe think about them historically as for mom and pop. Some of them are pretty significant grants to maybe medium-sized businesses. So we'll keep an eye on that. We appreciate you taking the time with Elise to present on that. I know, CJ, you have a hard stop at 9 a.m. Eastern time, so we may have time to circle back for live questions, but if anybody has questions for CJ in particular, he'll have to drop at 9 Eastern, which is when we're scheduled to end. And keeping that in mind and being mindful of people's time, Tripp VanderWal is going to bring us home with some information about recent Department of Labor and IRS guidance that relates to employee benefits issues. So I'll turn it over to Tripp.
Thank you, Erik. I am Tripp VanderWal, a member in the firm's employee benefits and executive compensation practice. I'm going to talk to you today about a few flexibility options for flexible spending accounts provided by the Consolidated Appropriations Act, and then subsequent IRS guidance, some benefit deadline extension updates, and then some requirements for group health plans regarding COVID testing and vaccinations. Let me quickly note before I get started that we have done client alerts on all of these topics. One was released 2 weeks ago on Monday, and we released 2 last week Monday. So if you find our firm's COVID website, you can find additional client alerts and links to the underlying guidance out there if you have additional questions, or you can always funnel those to me. So beginning here, the Consolidated Appropriations Act, which was signed on December 27, 2000, so last year, allows employers to make following optional changes. So again, these are not required with respect to both medical and dependent care flexible spending accounts, or FSAs. First is they allow unlimited carryovers of unspent account balances under medical and dependent care FSAs, and that's not only from the 2020 plan year to the 2021 plan year, it is also from the 2021 plan year to the 2022 plan year. This is significant for those of you that are familiar with carryovers and how they apply to FSAs. You know that medical FSAs traditionally were limited to a $500 carryover that has since been increased to $550, but dependent care FSAs were never permitted to have a carryover. So basically, we've uncapped these amounts, at least temporarily, and added the dependent care feature to the dependent care FSAs. For those of you that use grace periods instead of carryovers, you can't use both. The Consolidated Appropriations Act, or the CAA, allows grace periods that are applicable for the 2020 plan year and 2021 plan year to be extended for at most 12 months after the end of the plan year. So again, most grace periods, which you can use again under both medical and dependent care FSAs, presuming you don't have a grace period, are typically limited to 2.5 months, and you can extend those for a full 12 months. Please note that the IRS guidance, which I'll touch on a little bit next, basically answers one of the questions we thought was true, in that an unlimited carryover or a 12-month grace period is really going to have about the same practical implication. There is some nuances of why you may want one or the other, and we address that in our client alert. Thirdly, we can spend down the medical FSA after a participant terminates participation in the medical FSA, but for a maximum of the remainder of the plan year for which the participant terminates participation in the medical FSA, and that's going to apply in both 2020 and 2021. Some of you on the webinar today may be familiar with this feature as it applies to dependent care FSAs. We typically refer to this as the spend down feature under dependent care FSA, historically has not been allowable under a medical FSA. Again, that will be temporarily allowable. One thing to note is that if you do offer this feature, that is not going to relieve you from your COBRA obligations under a medical FSA to the extent they otherwise apply. Next slide, please. Going on, a few more changes. So for the plan year for which the open enrollment period ended on or before January 31, 2020, I think another way to say that is the plan year that began on or after February 1, 2020, you can generally use a dependent care account to reimburse expenses up through the age of 13, so below 14, and that added one more year. Typically, you can only use those dependent care accounts for kids that are 12 or older. So people that turn 13 in that plan year, you can use dependent care accounts. Of course, the reason for that is, if I had a kid turning 13 in 2020 and I put some money in my dependent care account, thinking I was going to need that for dependent care expenses, only to see my child care facility close down, this is going to allow you to use that money on that kid, even though they turned 13. For the plan year after the one that we're referring to right here, you can also use that for kids that either turn 13 in the first plan year or in the second plan year, but only to the extent that the dependent care FSA either provides a grace period or carryover, and you're using amounts from this plan year beginning on or after February 1, 2020. The CAA also allows you basically, or allows employers to provide the opportunity to make mid-year pre-tax election changes under a medical or dependent care FSA for any reason. Typically, we need to incur a certain event that allows those changes to be made mid-year. This basically says, hey, you can write this, employers can allow these changes to be made for any reason or no reason at all. And then finally, the CAA provides additional time to amend FSAs for any changes which the employer wants to allow. Typically, so if your deadline to amend the FSA under the guidance by the CAA is going to be the last day of the calendar year that begins after the plan year in which the changes were allowed to take effect. So using a calendar year FSA, for example, if we make changes that will be allowed during the 2020 calendar year, you will have until December 31 of 2021 to formally amend your FSA to incorporate those changes. The only other rule is essentially you have to administer your FSA in a way similar to how you were going to amend it down the line. Next slide, please. The IRS about a week ago issued IRS Notice 2021-15, which essentially provides additional guidance on these FSA changes allowed by the CAA, but also gave us some additional, I would say some bonuses, things that we weren't expecting. So an FSA can allow a grace period or a carryover and extended period, grace period, even if they didn't previously allow a carryover or grace period. So, one question that we had is we get this guidance that we can allow an unlimited carryover, we can, allow a 12-month grace period. But what if we never previously had that? Typically the rules say you have to amend your FSA during the plan year in which the carryover or grace period will apply. And, this guidance didn't come out until December 27, 2020. So for those of you with calendar year FSAs, there wasn't a lot of time to amend your plan to add a carryover or grace period. The IRS guidance is basically you can still put those in place and amend your plans to do so even though that period is over. Also provides the IRS Notice 2021-15 provides additional flexibility. So, as I mentioned, the CAA basically allows you to make mid-year pre-tax election changes related to health FSAs. Similar to what the IRS did in 2020, they are going to allow those mid-year changes with respect to group health benefits, which includes medical, prescription drug, dental, and vision. You can make those mid-year pre-tax election changes for any reason. Now, keep in mind that if you're going to allow mid-year enrollments, you're probably going to want to run that by your carrier if you're fully insured, or your stop-loss carrier if you're self-funded, to make sure that they will also honor those elections. And if you are going to allow an employee to drop comprehensive medical prescription drugs covered. You can really only do that if they provided a written attestation that they either are enrolled in other comprehensive health coverage or will immediately enroll. And that appears only to apply to employees, not requests to drop spouses or dependent children. Kind of an odd or surprising addition was allow mid-year conversions between a general purpose and a limited purpose medical FSA. This is typically something that can't be done and may allow for some planning techniques because, of course, a limited purpose medical FSA is necessary for participants who are enrolled in a high deductible health plan and want to remain eligible to make or receive HSA contributions. So I've had employers try to implement high deductible health plans in the middle of an FSA plan year, and that carries a lot of problems with it. This may be a situation in which we can do that and eliminate some of those problems. Again, this guidance appears to only apply in 2020 and 2021, and then potentially to carryovers of grace periods from the 2021 plan year. Finally, those of you that have been watching our webinars know that the CARES Act that was signed into law last spring allowed medical FSAs, HRAs, HSAs, Archer medical FSAs to cover over-the-counter drugs without a prescription and menstrual care products as of 1/1/20. Under the current rules, IRS basically has said with respect to medical FSAs, you can only cover those once you actually formally amend the plan and do that prospectively. You can't have retroactive amendments. The same is arguably true with respect to HRAs. What we learned is that the nationwide, or most administrators, and even the nationwide administrators of FSAs, kind of uniformly adopted this rule without even consent from their clients as a matter of uniform administration, and turned that on 1/1/2020, and essentially then put all of their clients' medical FSAs out of compliance with the rules. So this IRS Notice 2021-15 provided a little carrot there and said retroactive amendments to medical FSAs and HRAs to cover these as of 1/1/2020 are okay. Next slide, please. Benefit, shifting gears a little bit, benefit deadline extensions. Last May, we got a release from the Department of Labor and IRS titled Ebsa Disaster Relief Notice 2020-01. Under this release, various benefit plan deadlines were extended or paused during the outbreak period. Those deadlines were related to COBRA elections by participants, COBRA premium payments by participants, and the provision of COBRA election notices by employers. Also applied to enrollment requests due to HIPAA special enrollment events, such as having a baby, getting married, or losing other health coverage. And then finally, claim and appeal submission deadlines were extended. So these deadlines were extended during the outbreak period, which began March 1, 2020, and is scheduled to run through 60 days after the presidentially declared national emergency declaration expires, which hasn't happened yet, and frankly probably won't happen for a little while yet. The problem, of course, is that the IRS and DOL only have the statutory authority to extend these deadlines for a period of 1 year. That 1 year period was up on February 28th of 2021. And so the big question is, does that kind of unpause the deadline? Do we start counting these deadline periods again for everybody? There's a couple different interpretations, and next slide, please, Jeff. The Department of Labor did is they issued Disaster Relief Notice 2021-01 in a way that was most friendly to participants, but probably least friendly with respect to an administration purpose. And that says that this 1 year period essentially is going to apply on an individual by individual basis. So for example, if I had a COBRA election, I needed to elect COBRA by April 1 of 2020. That period is going to be extended until April 1, 2021, which is 1 year later, unless, of course, which I don't think could happen anymore, the presidentially declared emergency ends and then 60 days expires. And so I think we're obviously too close to April. But again, generally you're going to be measuring out 1 year unless the outbreak period ends, and that will end it shorter. The disaster relief notice basically said that employers should act reasonably and in the interest of employees and their families who rely on benefit plans for their health and economic well-being. So you can interpret that how you will. I'm not sure that's entirely clear what that means. I think to some extent it's encouraging employers to be forgiving and flexible, which is all well and good. But again, I don't think you want to get yourself somewhere where you're extending coverage that you're not otherwise legally required to, only to find out that your insurance carrier or stop loss carrier, if you're self-funded, is going to say, yo, that was really nice that you decided to be flexible to your employees, but we're not on the hook there. So you have basically put yourself in a self-funded environment with respect to that individual without any protection of stop loss. So again, to the extent that you want to be flexible, maybe more generous than what the law requires, it's always a good idea to be bouncing off your carrier stop loss carrier partners. And then again, finally, the notice suggested that you may want to send affected participants a notice regarding the end of their extension. This wasn't necessarily a mandate. And if you were somewhat generic, if you previously notified participants of this extension last spring, may not require another notice. But if you sent them a notice that essentially this new DOL guidance now makes your previous guidance incorrect, probably wise to send a revised notice telling employees of when their extension periods will end. Next slide, please. Lastly, two more slides, just a quick cover on, just update on COVID testing and vaccinations. The DOL, HHS, IRS issued additional FAQs. These are in Part 44, really clarifying the requirement that group health plans, and this is both grandfathered and non-grandfathered group health plans, must cover COVID-19 tests without 1, participant cost sharing, 2, prior authorization, or 3, other medical management techniques. And what the FAQs clarified is that this includes individuals that are asymptomatic and have no known or suspected exposures, and HHS issued a press release along with this guidance that basically said, hey, if I want to go get a negative test before visiting a family member, maybe a vulnerable family member, my health plan has to cover that and can't impose participant cost sharing on that test. The FAQ said that, however, the requirement to provide it with no cost sharing, prior authorization, or other medical management techniques does not apply to COVID tests that are required for public health services or employment purposes. Now, it didn't give any guidance on what it meant by employment purposes, but potentially to the extent that you are requiring your employees to get a negative COVID test, when they arrive at the workplace or before they arrive at the workplace, those tests arguably can't be sent off to the group health plan and expected to be paid with no participant cost sharing. It may actually be required for the employer just to pay for that out of their own pocket. Next slide, please. With respect to COVID vaccinations, the CARES Act amended the ACA's preventive care requirements and basically stated that all non-grandfathered group health plans must cover COVID-19 vaccines without participant cost sharing and must do so within 15 business days of the COVID vaccination getting a requirement by the ACIP. This guidance clarified that all COVID vaccines have to be recovered, so you can't pick or choose. So that clearly means, obviously, the Pfizer biotech vaccination has to be covered, Moderna has to be covered, and the Johnson & Johnson, as many of the folks know, was recently got an emergency use authorization by the FDA. It received its ACIP recommendation on March 2, which means that non-grandfathered group health plans are going to have to start covering the J&J vaccine without participant cost sharing right around March 23, based on my calculation. This guidance also clarified that the group health plan has to cover a vaccination even if it's received by a participant who's not in the applicable prioritization category. So I've gotten outside of that. So, for example, I'm able to find my way into a provider that is going to have to dump vaccination at the end of the day because they have extra. If I'm able to get a vaccine there, my group health plan has to cover that, or is presuming it's non-grandfathered, without participant cost sharing, even though I wasn't necessarily within the participation category or the prioritization category. Finally, this guidance clarified that employee assistance programs and on-site clinics may cover COVID-19 vaccines, including administration, not necessarily required to, but may do that without losing their status as an accepted benefit, which is an important thing because without being an accepted benefit, these programs would likely have to comply with all the ACA requirements, which from a reality, being realistic, would not be able to do that. Next slide, please.
All right. Well, thank you very much, Tripp. We're right at time, maybe 1 minute over. So I want to be respectful of the cutoff, and it doesn't look like we have a big queue of questions. So if folks have questions that they do want to follow up with any of our presenters on, please feel free to do that, of course. And we want to thank you again for joining us this morning for our Monday morning COVID Roundup. We will continue to do this along with other webinars and client update content. Amy Scrow has been generous enough to link to some of those things in the chat box. We'd like to thank Amy for that. And then also Jeff Haywood, who's controlling things on the IT side. Thank you, Jeff, for your continued support. And we'll look forward to interacting with folks throughout this week. And hopefully we'll see you again next Monday. Stay safe in the meantime and have a good week. Thank you.